Good morning, Ms. Anderson.
Good morning.
You may proceed.
May it please the Court, I'm
Thank you.
Dorothy Anderson, Assistant Bar Counsel, representing Bar Counsel in this matter. There's 4 primary points I'd like to address this morning. The first one is our burden-shifting argument, which is that in a matter such as this, where a respondent attorney held a client's funds in cash in something other than a bank account for a period of time, he should have carried the burden of proving what he did with the funds that he admittedly received. And in the failure to do so, it is appropriate to presume that he has intentionally misused the funds that he cannot account for.
Will an inference do?
I mean, I think the Court could approach this matter in several ways. I mean, it could create the presumption, as the Louisiana and Michigan courts have done. It could create its own remedy and basically pronounce that.
What will an inference do?
An inference that he has misused them?
Yeah. Isn't that what the hearing committee did? They applied an inference, and because the money was so old and musty, and because it had serial numbers that coincided with the date that they were placed, they inferred that that the lawyer did not misuse the money, but in fact stuck it in a shoebox.
Well, let me clarify here. We really have sort of 2 different pots of money. There is the $2,000 which the respondent found purportedly in April of 2006 in his safe, and as you say, the hearing committee inferred that that was money that had been lost. Actually, Mr. Murray himself testified that he recognized that as Dee Dee's money. But what we're still dealing with here is this at least $1,386, which to this date has never been located, and which has, and Mr. Murray has not made any restitution of or otherwise addressed what happened to it.
Could I just, factually, I just want to make sure I have this in my head. So there's take the hearing committee's number of 11,000, right?
Yes, that's using, again, they said, I want to emphasize, they said at least 11 to 12.
Okay.
So all these numbers are minimums, yeah.
Okay. And then we subtract all the money that was known to have been spent on the house.
Correct.
Right? And then you subtract the 2,040. And then you're still left with 1,386.
Well, no, there's a caveat, because the respondent also withdrew from Miss Dee Dee's savings account $4,442. So you add the $4,040 to the 11, you subtract what he spent plus the 2, and you get at least $1,386.
Okay, thanks.
Okay. So putting aside whether or not the 2,000 was, well, the hearing committee found that that was money that had been misplaced in the safe. But we still have this $1,376, and those are the funds that we're asking this court to presume were intentionally misused. The second point I wanted to address is about this issue of misuse versus misplacement.
Why do you need a presumption? I mean, the arithmetic of the case seems to suggest that there's $1,385 that he still has.
The presumption is about intentional versus negligent or some other kind of misuse. That's what we're asking for here. It's clear that that money is gone, and the respondent certainly should be held responsible for it. But because of the violations of Rule 1.15, the failure to account, the failure to make records of the money, the failure to put in a bank account, we're asking for a presumption of intentional misuse. So I think perhaps that answers your question. Maybe not.
Well, I guess the question, going back to it, I mean, you can put him on the stand. You did say, "Where's the money?" He'll tell you or not tell you. And why can't you make an inference, as Judge Spina suggests? If he refuses to answer and take the fifth, you may take an inference. If he gives you an answer which you consider to be false, you may make an inference. Well, but why, if he gives an answer which you consider to be credible? I guess you have to burst the presumption. This is a bursting bubble presumption.
No,
or
what happened here is that he did testify what happened to the money. He testified that he gave $1,500 back to Ms. Dee Dee when she came home from the nursing home. The hearing committee disbelieved it. It said, we don't believe that she did that. However, the hearing committee said nothing about what happened to the $1,500. I agree that an inference could have been made, but they didn't make it because they insisted that the burden was on Bar Council to somehow trace this money. And they said, well, you didn't show that he deposited a big bunch of cash into his, his personal account. And, you didn't trace the money and show that a $20 bill that came out of Miss Dee Dee's freezer wound up at the grocery store down the street from the respondent's house. And that, therefore, since you didn't prove that the respondent misused the money, we're just going to say that he misplaced it.
Would you be happy if we were to say, or would you be, I don't want to say happy, would you be legally satisfied if we were to say that, no, this is commingling, and there is still $1,385 in funds that have been commingled that have not been accounted for?
Well, I think the question is, how do we fit this into the, jurisprudence of discipline? I mean, we have all these cases out there.
So you're saying it's not enough that it's commingled, that has to be a presumption of misuse?
Yeah, the money is gone. He took dominion over the, excuse me.
It's not the presumption, it's a presumption of misuse, but misuse can be inadvertent, correct?
That's right. There could be negligence.
So what you're focusing on, because we have different levels of discipline, is did he do this intentionally? So he lied under oath, says the hearing list committee. I don't believe you that you gave her $1,500 in cash.
Right.
Right? They didn't use the term lie under oath, but essentially that's what I disbelieve your testimony is. He says, because he's missing approximately $1,500 that he cannot account for.
Well, he never said that. Again, he said he gave it back to her. They disbelieved.
No, I understand.
Right.
So he says, I gave her cash.
Yes.
Cash. And the question is, first of all, do we believe that? If we believe that, because there's other evidence, not a problem, right? 1,500, so that accounts for that, and the fact that he didn't keep a list of it, that may be one violation, right? Now you have a hearing, a fact finder who says, don't believe that.
Right.
And then the question is, what do we conclude from that? One thing to conclude is he didn't keep adequate records.
Well,
right?
there's
That's
no
one
question.
thing. One thing to conclude. Another thing to conclude is that he commingled it.
Right, which he may or may not have, because...
And the third thing to do is, no, he actually intentionally misused it, which may have been commingling. He meant to give it back again. We've got a lot of those cases. Or he actually just took it.
Right.
And you're asking to say, when there's in the absence of any evidence is what happens to it, which you cannot establish. You can establish it was commingled when the check is deposited into the lawyer's personal account rather into the IOLTA account, no problem. If somebody's given cash and you don't know where it went, your point is, A, burden of proof shifts, and B, the burden should be, or the conclusion from that should be that it was intentional. Correct?
Yes, exactly.
It-
Yeah.
At some point, but maybe, I don't mean to interrupt your flow, but at the very end of your brief, you say, well, if nothing else, this is like negligent misuse with deprivation.
Well, there's two kinds of misuse in Bar Counsel's cases. There's intentional and there's negligent. Generally speaking, we have to show some kind of intent. As Justice Marshall points out, usually we have bank records. We can show that somebody put $10,000 worth of their client's money in, and the next day they use the $10,000 to, pay their child's tuition bill or something.
And they get on the stand to say, my secretary did it, I didn't realize it, and I was always going to give it back. And you see here, I put it back in again.
Right.
Right?
Yes.
And so there may have been commingling, but the money is back.
In that case, we call that misuse without deprivation, because if
Correct.
the client gets the money when the client is entitled to it, that's misuse without deprivation. In this case, there's no issue about the deprivation. She's never gotten this money back.
She may have gotten the money back, except the fact finder found they didn't believe his testimony that he
Right.
gave her $1,500.
Right. So at this point, we take it, the fact finder's facts, that she never got the money back. So the question is, well, how do we characterize that? And again, we're not able to prove intent when we're dealing with cash. I mean, the whole idea of these rules is that clients have to treat their attorneys have to treat their clients' cash very seriously. They have to count it, they have to make records of it, they have to, most importantly, they have to put it in a trust account, and they have to furnish accountings to a client, or in this case, the client's guardian, when they're requested to do so.
Let me ask you this question. Let's assume that I get it. What was the original amount? $11,000?
The hearing committee found at least
Well,
11 to
let's
12.
just at least. Let's say $11,000. Okay? There's a check for the $11,000. Okay, and it goes, instead of going into the attorney's IOLTA account, it goes into his own account, and he withdraws $11,000 in cash. Okay, he's got cash, and then sometime later, it turns out that he has put into the IOLTA account a sum of money that amounts to $9,500, leaving $1,500 unaccounted for. He says, of the cash I took, I gave my client $1,500. Hearing committee does not credit that testimony. So $1,500 is missing, right?
Yes.
Is that any different from this case?
It's intentional misuse. The difference is that we then have a record of the money coming in and the money going out, and we
You
can...
don't have a record of what happened to the $1,500 because he hasn't
No,
kept
but
a record. He doesn't have a
just-
receipt that she signed, and that's, I think, isn't that intentional misuse?
Absolutely. Just putting the money into a personal account is intentional misuse. I mean, this court has said on several occasions, it's the exercise of dominion over the funds that makes it conversion. And in this case...
Did I understand you to say that there were 3 jurisdictions where there's the presumption that if the attorney must explain the money?
2 jurisdictions, Louisiana and Michigan, have adopted this rule specifically pertaining to cash, where an attorney says, I had that money in cash in my office, or they use the expression black box. The burden is on the attorney to...
What about the other jurisdictions?
Those are the only 2 that I could find that even address this matter, Your Honor.
Do you want the same burden shifting in a disciplinary action based on breach of fiduciary duty as there is if it's a beneficiary suing the fiduciary?
Well, again, we're looking for something very narrow here having to do with cash. We're not looking for a general rule that would apply to the vast majority of cases where attorneys handle the money the way they're supposed to. So
you're making...
But we do use the analogy that, generally speaking, a fiduciary has the burden of showing that he disposed of the principal's cash, to the benefit of the beneficiary. So we're using that as an analogy.
Right. The burden is generally to justify the use is on the fiduciary.
Right, to show what you did with
And
it.
here you're asking for that same type of burden to be placed on the attorney.
That's
which is
right.
different from the normal burden in a disciplinary proceeding.
That's right.
We already have a rule in place that requires attorneys to deposit cash into an account, a trust account, don't we?
That's correct. And the question is, what happens to them if they don't do that? How do we...
And there's no other way, there's no other permissible way for a lawyer to hold cash or to hold money, is there, other than to put it into a trust account?
Exactly. Right. So he breached the basic rule, and now we can't account for the money. And the question is, how do we deter this behavior? I mean, the penalty for doing this has to be greater than the penalty for acting according to the rules and stealing it. So in other words, I mean, if he had put it in the bank account and taken $1,500, we would be able to see that from the bank records.
Why do you say the penalty has to be greater than if he had stolen?
Well, as much as. I say
But-
the penalty for ignoring the rules has to be at least as great as the penalty would be had he done this.
Stealing?
Excuse me?
Why? Why should it be as great as it should be for intentional stealing?
Because when an attorney violates all these rules, he allows himself to take money without any evidence whatsoever. I mean, like the Indiana court said.
But
He's dealing here with an incompetent woman. She can't say how much there is. He's the only one who can say how much there is, and he can't account for it. Can I just make, I see my yellow light. Can I just go on to one other point?
You've got 31 seconds.
31 seconds. I also want to address the 2000. In April 2006, he finds $2,000 in his safe. He knows that that's Miss Dee Dee's money. He then spends 8 months for dealing with his legal problems and not giving it back to her. That's intentional conduct, just as if he had taken that money to begin with. He knows it's hers, and he puts his interests in, dealing with the bar disciplinary proceedings, another civil proceeding which is taking place, above her interest. She has an absolute right to that money. That's intentional conduct, which violates Rule 8.4C. Bar counsel is looking for a lengthy suspension or even disbarment in this matter. Thank you.
Thank you, Ms. Anderson. Mr. Bourgeois, good morning.
And good morning, Your Honor. It is a pleasure and an honor to be in front of you. I start by acknowledging, absolutely, my client made a mistake, and he mishandled Miss Dee Dee's money, and he deserves the sanction that this court and the Board of Bar Overseers has given to other clients who have made a mistake.
What happened to the other $1,385?
The short answer is it has been lost. My client's position was
No,
that...
that's what your client's position. I thought he testified that he gave it to his client.
That is correct.
Well,
That was his
that's not
testimony.
lost.
His testimony was that when he finally met with her after she got out of the hospital, he charged her an $850 fee and he gave her back $1,500. The hearing panel said that they did not credit that testimony, but they did not find that he deliberately lied.
Could you clarify, was she incompetent?
She suffered from early signs of dementia with occasional insulin imbalance problems. So there were times, sir, when the healthcare nurses found her to be in a daze, but that was more a function of the insulin diabetes than actual mental
What I'm
health.
trying to get at, though, was it reasonable for him to give cash to a person who was prone to not being able to function properly?
In my opinion, sir, no, it wasn't. My
Mr.
client
Bushra,
mishandled the cash.
Let me ask you this. What he should have done, of course, is as soon as somebody hands you a lot of cash, it could get stolen, you could be, could be taken out of your house. You go to a bank and you open up an IOLTA account and you put it in there. That would have solved all the problems. He says he gave it back to her, so it's not lost. He says he gave it back to her. Either the hearing list committee doesn't believe it or she denies that. I mean, she's not in a position to deny it. Why didn't he just pay up the $1,500 when there was a subsequent guardian ad litem?
The short answer is we settled the case, and
For what case?
there was a parallel case with the guardian ad litem that was ongoing in the Superior Court, and that case was settled. And the guardian
But
ad
why
litem...
does the guardian ad litem have to sue you? Why don't you, as soon as you realize there's a shortage of funds, to say nothing about holding on to the, how much was it, 800 that he held on to afterwards?
2040.
The reason for that, Your Honor, the guardian ad litem sued because Ms. Carmody initially testified that she found $50,000. The hearing panel did not credit that testimony either, and she essentially recanted it.
So
that is what caused the Superior Court suit.
So for purposes of these proceedings, the bar discipline proceedings, at least on this record, there is $1,385 that would have been, that should have been paid to the client in this case, has not been paid. Whether it's lost, whether he intentionally converted the money, it's at least her money, and she has not received it.
And the person, sir, who's in the position to advocate and litigate for that was the substitute guardian, and we settled the case with them. They were happy with the amount that they received.
But this is a bar discipline case. That's not
I understand
binding on
that,
this.
but it appears to me that bar counsel's position is that we should put back even more money than the guardian asked. Now, perhaps that's true.
Don't the facts cry out for that result?
Well,
I mean, the arithmetic of the case it shows $1,385 is missing.
if you accept all of the arithmetic the way in which the hearing panel did it, that's correct.
Well,
but
those
there
were the findings that were accepted by the board and accepted by the appeals panel.
And I agree with that.
Is there any reason why we should not conclude that $1,385 is missing?
I think on the basis of the record in front of you, you have to do that. But again, the question, sir, is why is it missing? Is it because my client stole it, or is it because he's dishonest? That's the fundamental question.
No, but that may not be, though, because let me ask you this. Why is this case, at the very least, not like, Ms. Anderson would say, a negligent misuse with deprivation? We have deprivation, and at the best, we've got a negligent loss, which I would say is equivalent to misuse.
The critical issue is the word use, okay? But let me give an example of the Bayless case, where as a result of ongoing negligence as a fiduciary, as a trustee, those beneficiaries lost hundreds of thousands of dollars. That respondent went bankrupt. A portion of it was found to be non-bankrupt, and the lawyer got a public reprimand. In the Kidd case that Justice Cordy handled, again, there was wholesale neglect and a number of mistakes that were made. That lawyer got a suspended suspension. In Abramowitz, we had a similar situation where $20,000 was missing for almost 3.5 years. That lawyer got a public reprimand.
Yeah, but in this case, we have a clear ethical rule that requires lawyers to place cash into a trust account. There is absolutely no other alternative. Why isn't the only permissible inference in this case that he commingled the funds? It's as if he put it in his own cash office box.
Because, Your Honor, lawyers who make mistakes and lawyers who steal are not morally equivalent.
No, they're
we
not.
start to blur that line.
Mr. Bourgeois, we're not blurring that line, I don't think. But let me ask you this. Your client was given $11,000. I know at least as, okay, $11,000 in cash, and puts it into his bank account, okay? Hypothetical.
Yes.
He then writes out a check to cash.
Yes.
And he takes $11,000 in cash.
Yes.
And he then pays off various house improvements, right? And he then has $2,040, whatever it is, left. And then he says, oh, the other is just lost.
If he knows he has it, if he's
He knew he had it.
in your scenario, where the money is put in the bank, where it's carefully counted, where it is tracked,
It's one
and then
transaction. He puts it in,
yes.
and he takes out $11,000 in cash, because that's the way he likes to deal with his clients. He likes to do walk around, he likes to pay contractors in cash, heaven only knows why, but there isn't exactly an ethical rule that doesn't say that, except he shouldn't have written the cash to himself. Why shouldn't there be an influence? First of all, why shouldn't the burden of proof go to the client to show what he did with it? Do you agree with me that the burden should shift to him?
As a practical matter, the burden shifts to show what he did with the money.
Right.
And if he cannot show, then the client is damaged, and then we use the rules we've always used, which are negligence, harm to the client, damage to the client. But we do not brand that lawyer a thief without some higher order of proof. And that's what Bar Counsel's asking for. Every lawyer in an estate who loses money, who loses jewelry, who loses some fungible commodity is going to be branded a thief until he or she proves otherwise.
No, not branded a thief. He may, for example, show that he put it into an investment that he shouldn't have done, or that he, frequent cases, he pays off his rent and then puts money back into the IOLTA account, and then it has to do with the temporary deprivation. But when the cash is actually gone, why is it that we should not draw an inference that he intentionally kept the cash as opposed to an inference that he simply lost it?
If you have facts that tend, like the case from Louisiana with my sister cites, that tend to show that the lawyer is dishonest, that the lawyer is acting in bad faith, that there are reasons to believe the lawyer took the money. But if it's simply an issue of the lawyer losing a fungible item, like cash, jewelry, investment coins, bearer bonds, or any number of things, lawyers, as long as they've been handling estates, have been losing things.
But there's no excuse for losing cash.
Absolutely.
I'm saying legally, there, as a matter of law, that money should have been put into a trust account where it was unlosable.
Sir, there's no excuse in any of the cases where lawyers have made mistakes and clients have been damaged, and those lawyers get public reprimands. And I'm not making excuses.
Why isn't this the same as commingling in his office cash account?
Because what's missing in commingling is the concept of the money being put with his and spent with his control. He simply lost
He
it.
had it in a file drawer in his office.
That's not commingling. It's not conversion. What paragraph 13 of this complaint baldly says, my client commingled the funds and intentionally converted them.
Okay, we're
Bar
talking about
counsel couldn't prove it.
commingling, not conversion, just commingling.
Commingling requires a mixing of the lawyer's money with the client's money. This man just lost the client's money.
But Mr. Bourgeois, you keep saying that, but in fact, he testified that he gave it to her.
Yes,
He did not testify that he lost it.
but that does not, I'm answering the question about commingling. Commingling refers to the lawyer's exercise of the dominion over the client's money as if it was his or her own.
Are
That
you
didn't
telling
happen
me
here.
that he paid all of the house improvements with the actual cash that the housekeeper had turned over to him? Or did he take some other cash?
There was $4,000 taken from the bank and $6,500 used to refurbish the house.
Mr.
Yeah,
Bourgeois, if
the 60 was the 6,500 the actual same dollars that the housekeeper had turned over,
Yes, that was the evidence, yes.
and the 4,000 as well
No, the $4,000 came out of a savings account at Westfield Savings Bank, Your Honor.
of the clients.
Yes.
If I understand you correctly, and please correct me if I'm wrong, you said you did not object to the burden shifting that Bar Counsel is requesting, but all you're asking is that once the burden has shifted, or while it's shifting or as a result of it, that the attorney not be treated as if it were intentional misuse, but that it be considered that it's still possible that it's negligent misuse.
Yes, I don't
Is that
see.
what you're saying?
Yes, because the burden shifting shouldn't be significantly different than it would be in a civil case.
case,
Any
that's what I'm saying.
fiduciary,
Right.
once you find you've got money and you can't account for it, you're charged
So you
with
agree to be the normal
it.
civil burden.
Right, but that doesn't mean you stole it, and it doesn't mean that we equate for discipline purposes a lawyer who's lost client property with a lawyer who's stolen client property.
Mr. Bourgeois, why wouldn't, accepting that for this premise, why shouldn't we treat cash differently than jewelry? I mean, because cash, as Justice Spina has said, there are separate rules about what you have to do with cash. There aren't separate rules about what you have to do with other kinds of property.
There are two reasons. Actually, there is a rule that says the client must always safeguard client property and notify the client that he or she's received it. But secondly, Bar Counsel's argument about cash is that it's fungible and easily stolen. Well, so aren't investment coins, gold investment coins, jewelry,
but at least there,
bearer bonds.
At least there, you can attempt to trace them.
Mhm.
You can attempt to trace them. Let me just ask you this. I'm very troubled by the burdens. The Bar Counsel, the hearing committee found contained a total of at least 11,000 to 12,000. So 12,000 is the maximum.
Yes.
So let's say it's 12,000. I would take that as a finding that it's 12,000. Then there's a little footnote that says, essentially, Bar Counsel is charged with carrying that burden. Right? This is difficult. This is difficult because you have a housekeeper who testifies. Her memory's fuzzy. She says she saw lots of packets. That they were mostly 20s, I think. And let's assume it was $20,000. He didn't do what he should have done, which was to take the money and put it into an account. Now, if he had taken whatever he was given and put it into an IOLTA account, and he only put in $8,000, Maybe the housekeeper took a couple of thousand, maybe he took a couple of thousand. I don't know. He's complied with the rule. But where he doesn't do that, why should I give your client any benefit of any doubt anywhere along this road?
The short answer to that is my client should be sanctioned. But as the dissenting member at the board said, we have to look at this in context. This man did an enormous amount of work. He cleaned her house. He visited her at the hospital every day. He was her friend. He was her advocate. He fought on behalf of her so that her house wouldn't be sold. He actually drove her sister to the hospital. He did all this, and he charged $850 only as a sense of her dignity. And the hearing panel heard that, looked in his eye for 4 days and said he made mistakes and maybe he's stupid, but he's not a thief.
Did he have trust accounts for other clients?
Yes, sir.
Not this one?
Sir, my client made a mistake,
He
but he's not
he made a
dishonest.
prior mistake. He had a prior, there was a history of discipline in this case
I understand that, and that
for,
is,
for this same kind of thing.
well, respectfully, the dissenting member noted it was not for the same thing, and it was at a different time. I'm not saying my client didn't
When
make a
was
mistake. Excuse me?
When was it?
It's a little
The,
before.
the estate letter in the admonition was in 2001. It was given in 2003.
And when did the events take place here?
Here, between 2003 and 2004.
That's the same year.
That's correct, and the timing and the relationship of that, I'd ask you to look at the dissenting, Ms. Dionini's dissenting opinion. She was one of the 3 members on the board panel, and her recommendation was, again, public discipline. The issue,
If we shift the burden here, has your client established that he negligently and not intentionally misused the money?
I believe he has. What kind of a thief hangs on to musty old money for 3.5, 4 years?
A bad thief.
Well, that's, but
Agreed.
that's,
Agreed. But there is a world of difference, Your Honor, between somebody who steals and acts intentionally and someone who simply makes mistakes.
Mr.
And we have got to
Bushwalker-
credit the hearing panel on that, finding that he...
Could I just ask you this? Is your client a sole practitioner?
Yes, ma'am.
If there are no further questions, thank you, Mr.
Thank you
Bushwalker.
very much, Your Honors.